Good afternoon, everyone. My name is Jessi Thaller-Moran, and I'm a partner in the Brooks Pierce Raleigh office. If you are here with us on your lunch hour, it's because you've caught wind of some developments in wage and hour law that we're seeing coming down the pipeline, and we're going to do our best to pack this hour full of some information that is helpful and hopefully at least mildly of interest. As I mentioned, I'm Jessi Thaller-Moran. I'm a labor and employment attorney based in our Raleigh office, and I'll let my colleague introduce himself.
Hey everybody, my name is Kemper Patton. I'm a labor and employment attorney as well here in Raleigh with Jessi, and happy to be here to discuss some new updates with the Department of Labor.
And so just a few housekeeping topics before we dive into the content. There is a chat box in the webinar. If you have questions you'd like us to discuss during the webinar, please feel free to submit them in there. I will say that this webinar is information. It is not legal advice. And so we would ask that if you have a question that's involving some confidential business information or particularly specific to your business, we'd ask that you keep that out of the chat box and consider reaching out to us separately. But we are happy to answer general questions about the law during the webinar. And then this webinar will be shared to everyone who registered, I believe, within the next 3 business days. So what are we talking about today? We're going to do an overview of wage and hour law. If you've been with us for a while, we've had to do this a few times in the last few years, but it is an area that is incredibly important for employers to get right. So we're going to talk about the wage and hour laws as they currently exist, some consequences if an employer finds themselves on the wrong side of those rules and laws, what to expect there. And then requirements for exemptions, so specifically minimum wage and overtime exemptions to federal and state wage and hour law. We're then going to dive into this proposed rule that is in the makings right now and that we expect to be rolled out in some form probably at the beginning of next year. And then we'll wrap up by talking about some high-level compliance tips you can do to get your house in order in advance of those changes. So there's our obligatory disclaimer. We can't give you legal advice. We're happy to give you lots of information, and we're happy to give you legal advice if you call us separately. So if you take nothing away from this webinar, if you zone out and eat your sandwich for the next 45 minutes, these are the things we want you to focus on. The rule as it's been proposed by the Federal Department of Labor, if that passes and takes effect, which we expect it will, the salary requirements to be exempt from minimum wage and overtime are increasing. Exemption requirements are specific, so it's more than paying someone on a salary basis. You have to meet specific duty requirements that we'll go into more detail discussing. But a salaried employee isn't automatically exempt from minimum wage and overtime. And again, even under the law as it currently exists, so before the rule modifies it, there is a risk of misclassification and a risk of liability. And so now is really the time to audit your files and get ready for the rollout in probably the beginning of next year. And with that, I will turn it over to Kemper.
Thank you, Jessi. And so throughout this discussion, we're going to be discussing various issues here and there, as Jessi mentioned, and we're also going to be kind of pointing out various myths that we see from time to time that that are important for employers to be aware of. So to start off with that, we want to just give a broad overview of the applicable wage and hour laws, which for our purposes are going to be the FLSA and the North Carolina Wage and Hour Act. So to start, the Fair Labor Standards Act, or the FLSA, this is the broad federal wage law that we all know and love. It's enforced by the United States Department of Labor, and it puts into place many of the wage and hour provisions that we all know about: minimum wage, of course, overtime as well for employees. But there are also many other aspects to the FLSA that are very, very important to be aware of. The FLSA provides requirements for tipping employees. It defines work time, which of course is very important for determining whether or not you pay an employee for things like training or when they're traveling. It has child labor requirements, record keeping requirements. We could have a whole presentation on the FLSA, but for our purposes for right now, we're just trying to give a general background of it. So here's our first myth. This is something that we see from time to time, particularly with handbooks. Some handbooks every now and then will get this wrong, or will just somewhat not exactly explain this the right way. I'll put it that way. And that is that unapproved overtime hours do not have to be paid at the overtime rate. And this could really even be expanded to unapproved working hours do not have to be paid because they're unapproved. And of course, this is not the case. It all goes back to the, you know, the most important 5 words of wage and hour laws: hours worked are hours paid. And with the FLSA, when those hours worked are over 40 hours in a week, they have to be paid at that overtime rate, which is 1.5 times the employee's standard weekly rate. So simply put, an employer cannot withhold overtime pay just because an employee is not approved to work overtime hours. Now, with that said, that doesn't mean that an employer can't discipline an employee for working unapproved hours. An employer certainly can. An employer just simply can't withhold wages for those hours worked. So moving on now to coverage under the FLSA. Who's covered by the FLSA? Well, there's 2 main requirements under the FLSA. There's enterprise coverage and there's individual coverage. Enterprise coverage is fairly straightforward. It's for all employees of employers with an annual dollar volume of sales or business done of at least $500,000. One thing to keep in mind here is that the Department of Labor does have the authority to, if there is an employer that has sort of different organizations that are legally separate organizations, the Department of Labor does have the authority to view those as one employer. If they are kind of sharing a common business purpose, kind of unified under one common control, they will view different legal entities as one employer for the purposes of meeting coverage under this enterprise coverage test. But the other side of it is the individual coverage test. This is for employees whose work regularly involves being in interstate commerce. This will bring in a surprisingly large amount of employees. It's not just traveling across state lines. This really gets all employees that are involved in interstate commerce, and it's a really surprisingly low burden to meet. Along with the enterprise and individual coverage, there's also just certain organizations that are automatically covered. This is going to be hospitals, medical and nursing businesses, things of that nature, as you can see here. But the take-home point here is that this is very broad, right? This is going to bring in most employers who are not very small. It's getting both the enterprise and the individual tests here can be met pretty easily. And you can be sure that the DOL is going to err on the side of covering employers. So moving on now to our next myth, which is that a small business in North Carolina is not subject to the FLSA. Kind of from what we've just been discussing, even smaller businesses that don't meet the enterprise test can very easily meet the interstate commerce test. And it's really an easy test to trigger. The United States Department of Labor has even given some examples of just how easy it is. Employees that produce goods that are sent out of the state. I mean, this can be something as simple as a secretary putting together a letter that goes to somebody out of state. Even janitors that work in buildings where goods are produced to be shipped out of state. I mean, it's a very low burden to meet. And so it's important to keep in mind that even very small North Carolina employers can be covered by the FLSA. All right. So now moving on to the North Carolina Wage and Hour Act, or as I'll probably refer to it, just the Wage and Hour Act. This is North Carolina's provision of wage laws. It's enforced by the Wage and Hour Bureau of the North Carolina Department of Labor. And it has numerous, of its own provisions, which are very similar, if not mirror images of the FLSA. I mean, minimum wage is a perfect example of that. But it's not completely the same. And moving on to coverage, it's a good area to start to show some of the differences between the Wage and Hour Act and the FLSA. So with the FLSA, as we just discussed, it has these various coverage tests, right? The enterprise coverage, interstate coverage. But with the North Carolina Wage and Hour Act, it covers all North Carolina employers and employees. So even those few employers that are escaping coverage from the FLSA will be covered by the Wage and Hour Act. There's some other differences as well. There's some differences with very select employees when it comes to minimum wage. These are employees like students, certain disabled employees and impaired employees. There are some very, very small differences when it comes to minimum wage that is really more so allow those employees the opportunity to work. Moving on to our next myth, though, the North Carolina Wage and Hour Act is the same as the FLSA. Of course, that's also not true. At the end of the day, in fact, the Wage and Hour Act actually is meant to intentionally fill some of the gaps of the FLSA, right? I mean, think about the coverage examples where the FLSA has the enterprise coverage and the interstate coverage tests, and the Wage and Hour Act simply applies to everybody. Other examples of how it fills these gaps, it provides for tipped employees that are not covered by the FLSA. It provides certain rules about deduction of wages and withholding wages that are not mentioned in the FLSA. And to take that point and move on to another myth is that sometimes we see that employers believe that they can withhold an employee's paycheck until the employee returns certain company issued equipment. So think laptops, company phones, company keys. Again, employers do not automatically have this right simply because an employee fails to, for example, return some equipment. This is kind of just a general tenet of the Wage and Hour Act overall, is that when you want to withhold wages, there has to be something specific in writing where the employer or where the employee is authorizing an employer to withhold wages in advance. And finally, one more quick myth before I turn it over to Jessi to talk about some of the enforcement provisions for the Wage and Hour Act and the FLSA. We haven't really mentioned independent contractors and their coverage, as well as volunteers under the Wage and Hour Act and the FLSA. And so naturally, you might think, yeah, independent contractors, volunteers, they're not covered by the FLSA. They're not covered by the Wage and Hour Act. So I don't have to be worried about overtime or minimum wage for my independent contractors or for my volunteers. Well, true, but also kind of not true in a sense. Yes, it's true that independent contractors and volunteers are not subject to wage requirements under the FLSA and the Wage and Hour Act. But you always have to be cognizant of what happens if it turns out that these folks, these independent contractors, for example, are misclassified, which of course is just simply always a risk with that relationship. If it turns out that they're misclassified, then the employer is going to be liable for all of the overtime and minimum wage requirements prior to while the employee appeared to be an independent contractor or a volunteer. So true, the independent contractors and volunteers are not covered by the Wage and Hour Act and the FLSA, but you still have to certainly be aware of potential consequences that misclassification could lead to. And with that, I will turn it over to Jessi to talk about compliance with the wage and hour laws.
Yeah. So I want to, circling back to the independent contractor takeaway, it is certainly not a recommendation that you start treating your independent contractors like their employees. But it's just another reminder, there is a temptation to view the independent contractor model like it's an easy way to not have to hire an employee. And sometimes it works and sometimes it actually creates more legal issues in the long run. So just something to be cognizant of. As we're talking about compliance and enforcement, I'm going to touch on a couple of different angles to be aware of when you're talking about the FLSA, so the Federal Wage and Hour Act. This can cause trouble a couple of different ways if someone is accused of not being in compliance. Employees can initiate the process by filing a complaint with the U.S. Department of Labor. If an employee does that, or if an employee cooperates with an investigation conducted by the Department of Labor, they are protected from retaliation for that action they took. So you cannot, in other words, terminate someone because you've learned that they've gone and stirred up trouble for you with the Department of Labor. Employees also have the option of going straight to court and bringing a civil claim. So in the first example, you're dealing with the agency who might be investigating the company. In the second example, you might be defending a lawsuit. And then the Department of Labor will on occasion bring claims in courts on behalf of employees. And you might see these things in the news from time to time, because when they file a high profile lawsuit, they'll often publicize it as an example of the enforcement efforts they're taking to apply these laws. With the North Carolina Act, employees can go to the North Carolina Department of Labor. The U.S. Department of Labor and the North Carolina Department of Labor have a memorandum in place that facilitates the sharing of information between the agencies. So it's possible for a complaint to start in one place and end up in both places. And again, employees can also file claims straight in North Carolina. Again, you can end up with either Department of Labor or both knocking at your door. And then for both the federal and state laws, you have collective or class actions. Collective actions fall under the federal law, class actions under the North Carolina law. The idea being that a whole group of employees who are similarly situated can pursue claims as a group. So again, you see this in the news sometimes with recently, we've seen some actions along these lines with assistant managers at certain retail operations. They kind of band together and bring their claims as one group. So just something to be aware of. And then when you're talking about investigations by either or both Department of Labor, sometimes it's initiated by an employee. It can also be sort of self-prompted by something that's come to their, that they become aware of for some other reason. Occasionally that is because agencies are sharing information between one another. So something that starts with the IRS can end up with the Department of Labor or vice versa. Investigations can be quite costly and time consuming. An investigator can come in and interview employees, review files, seek specific information from the employer. It can lead to a lot of lost business time and sometimes more significant consequences. And one of those things is that an investigator might end an investigation by imposing a fine. So that's before you've even gotten into the court litigation side of things. You might be dealing with a fine from an investigator. Next slide, please. And so what are we talking about when we say fines and potential verdicts in court? So typically with the FLSA, it goes back 2 years from the date the complaint is made. So if I file a claim today that says I haven't been paid minimum wage for the last, during the time that I've worked here, it will look back 2 years when calculating how much money I'm owed. However, if a violation is willful, that is, if the employer either intentionally broke the law or kind of ignored facts that any reasonable person in their position would have, it would have caused alarm and they would have changed what they were doing, that's a 3-year look back. So you're potentially looking at a verdict that looks back 3 years for one or more employees, calculates how much money they were owed, and then can impose additional penalties on top of that. A point here to note, because it will come into play as we're talking about the exemptions, is that if an employer has insufficient time and pay records, so does not have employees regularly recording their time, has not kept pay stubs, doesn't enforce employees having to accurately and timely report their time worked, a court or an investigator is going to defer to what the employee recalls they've worked. So it's the best preparation that an employer can do, other than auditing their files, as we're suggesting, is making sure that it has robust payroll systems in place. So again, penalties, you can be penalized for just not having sufficient records. That's a penalty on its own. You may be ordered to, the company could be ordered to repay unpaid wages. That might include minimum wage and overtime. Liquidated, which is double damages. So if a court determines that I'm owed $100, liquidated damages would be $200. And then someone who brings a lawsuit in the position of the employee here can also collect attorney's fees and costs. In serious matters, the law does allow for imprisonment and criminal fines. So again, a wage and hour violation can snowball into something quite serious. North Carolina's act looks back 2 years. It doesn't have that willful language like the FLSA, but it does have, again, those penalties that can stack on top of one another. And so just some examples, there are a lot of these available online if you want to see what the Department of Labor is up to. but you can see some pretty significant penalties and fines being doled out to employers here in different states. And then the other piece, yeah, actually this feeds well into what I was going to say. I forgot the slide was coming up. So the other piece that has been in the news over the last few years is this idea of assistant managers being misclassified on the basis that their title is manager. And Kemper will talk more about that in a moment. But if you have someone who's been in a role like that, has not been tracking their time, and then is found to be misclassified, you're in that position I mentioned a few minutes ago of having to rebut an employee's memory of how much time they worked with little or no evidence. So this myth that employers don't have to track time for employees who are on salary or who are managers, again, if someone is properly classified as being exempt from minimum wage and overtime, that's true. But many employees who are treated as exempt may or may not meet that exemption requirement. And it's a whole lot easier to defend misclassification actions if you have something to rebut what an employee is going to testify in terms of their working time.
All right, so I am now going to discuss some of the aspects of the exemptions to the FLSA in particular before we get into the new proposed rule from the Department of Labor. So as a general overview, I mean, what does it mean to be exempt from the FLSA? So the presumption is that if you're covered by the FLSA, then you're entitled to minimum wage and overtime. But there's, of course, going to be certain positions that for various reasons and based on the way that they are paid, they are going to be exempt from minimum wage and overtime requirements, or sometimes just overtime requirements as well. But whether this is the case is typically a very much a fact-specific inquiry, and to be safe, when there's a question, there's no penalties with treating somebody as non-exempt, right? So when there is a serious question, to be safe, you typically want to go the route of classifying somebody as not exempt. So to give a broad overview of these exemptions themselves, there are the white collar exemptions. Those are going to be your executive employee exemptions, administrative employee exemptions, a couple varieties of the professional employee. There's also the highly compensated employee. We have a few others as well, the computer employee exemption and the outside sales employee exemption. All of these are exemptions from both minimum wage and overtime requirements. Now, it's important, just for the sake of time, to be aware that there are other exemptions as well that are a bit more particular. The ones that we're going to talk about are really the main exemptions that we see a vast majority of the time. And some of these other exemptions that we're not going to talk about may not be exemptions from both minimum wage and overtime. They may just be exemptions from overtime. The motor carrier exemption is a great example of that for companies that involve driving large vehicles across state lines, for example. But we're going to just focus on these for now. So starting with the white collar exemptions, like I said, the administrative exemption, the executive employee exemption, the professional employee exemption, these all have really two main requirements. First, they require that an employee is paid on either a salary or fee basis at a specific rate of pay. And second, they require employees to have certain job duties matching one of these exemptions. So the first question, what does it mean to be paid on a salary fee base or a salary basis or a fee basis? They're different analyses, but at the end of the day, really what they require is that an employee's pay is not reduced for the quality or the quantity of work, right? That's what it means to be salaried. Less work in a week, more work in a week, poor quality, great quality, you're always going to count on that same paycheck. And that paycheck for now has to meet the paycheck has to meet a certain threshold, and that threshold for now is currently at least $684 a week. Now, I emphasize for now because, as Jessi will get to in just a moment, the proposed rule has potentially significant changes for that threshold of what an employee's weekly salary must be. So that's the salary, the fee basis side of the question. The next question is whether or not the employee performs the correct, quote unquote, primary job duties, right? the employee's primary job duties have to align with a certain recognized exemption, right? The administrative exemption, the other exemptions, for example, and whether that employee's primary job duty is their principal, main, major, or most important duty that they perform. And again, this is a really fact-specific analysis. It's not just what's on their job description; it's what their actual duties are, and sometimes it might be not necessarily what the employee does most often, but what their most important duty is. It could be based on other things as well. It's a really, really fact-intensive analysis that can vary widely, and it's really where we see a lot of the misclassification issues. So, taking one more myth here. Employers can deduct wages from salaried employees for part-day absences, cash shortages, poor performance. Of course, as we just mentioned, a salaried employee is not going to be having deductions from their wages based on these things, right? That's what makes being salaried. So if an employer is having deductions, if an employee is having deductions from their wages based on part-day absences, something like that, then you're probably running the risk of the employee losing that exemption from wage and hour laws. Another myth, kind of the other side of the coin, all salaried employees are exempt from minimum wage and overtime requirements. Again, this is something we hear from time to time. You get the impression that if you're salaried, you don't get paid overtime, right? That's never the case. Being salaried is never just enough. You always have to always carry out certain job duties under one of the various exemptions. And then one more myth before we get into talking about the specifics of some of these exemptions. Businesses with a sort of an all hands on deck model are more likely to have exempt employees. This is very likely not the case. Small businesses with all employees kind of carrying out very similar duties, oftentimes they're not all going to be exempt employees. The truth is, it's almost never the case that a company is just full of exempt employees kind of carrying out similar duties. As we get into these exemptions, you'll see that it's really inconsistent with a lot of the requirements that these exemptions have, that all sorts of employees can all be subject to these exemptions. So to start with these exemptions, we have the executive exemption. As we discussed, with these white collar exemptions, you have to be paid on a salary or fee basis, and then you have to have primary job duties that align with some of these specific examples. So with the executive exemption, you have they have to meet the salary or fee basis test, and then they have to have certain job duties. These job duties are listed out, and I won't read them off for you, but it's really what the really significant part of these job duties is: the management of the enterprise, right? This is not a small burden to me. And when it comes to managing the enterprise, this involves typically interviewing and selecting employees, adjusting pay and hours worked, recommending for promotions, handling grievances, disciplining employees. Kind of going back to what I was saying with that myth just before, you're not going to have a lot of employees doing all of these sorts of duties. These are really kind of high level duties, and so it's pretty significant burden to meet to be an executive employee under this exemption. So one myth here: all assistant managers are exempt because they manage operations when owners and general managers aren't around. Again, going back to everything we've been saying, it's your actual job duties that matter. It's not just the title you have. If you're just carrying out the decisions of other people, those aren't going to be looked at as your actual job duties, and it's really going to detract from whether or not you're actually involved in the management of the enterprise for the purposes of being an executive employee. Next, we have the administrative exemption. Again, you have to meet the salary basis or the fee basis test. Under the administrative exemption, you have to also carry out certain primary duties that include the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. But the second part of this is really where the administrative exemption becomes significant, and that is that the employee has to exercise discretion and independent judgment with respect to matters of significance. This is really what takes it out of all office employees falling under this category, right? So it's exercising discretion and independent judgment with respect to matters of significance. This involves comparing different options, making a choice free from supervision. It's really not an easy burden to meet by any means. So to take that with this next myth, the administrative exemption is a catch-all exemption for office employees. Of course, not the case. As we said, the administrative exemption really requires employees to be able to use their independent judgment, make decisions that can bind the employer, deviate from other standards. That's just not the sort of power you see most office employees having. And the next exemption is the professional employee exemption. Again, meet the salary basis or the fee basis test, and then you have to satisfy primary duties. These primary duties are kind of split up between two separate types of duties. One is the learned professionals and the other is the creative professionals. For the learned professionals, these are going to be your lawyers, your doctors, your accountants. These are going to be the people who it really requires some sort of advanced knowledge, typically acquired by a prolonged course of training or instruction. Whereas with the creative professionals, this is where you're going to get people whose performance of their work includes invention, imagination, originality, talent really in just an artistic field. This is where you're going to have musicians, actors, even journalists in certain scenarios when the facts are right. But with that, I will now move it on to Jessi to discuss some of the remaining exemptions.
Great. So the computer employee exemption, there are two things to note here. One is this is not meant to capture necessarily, your office IT person. There's a more specific requirement that we'll get to in a second. The second thing that's interesting about this exemption is that there actually is an option for the person to be paid on an hourly basis. The current hourly rate is here on this slide. Or you can hold to that standard salary basis, as we've been discussing. And then they have to be a skilled worker in the computer field. And obviously that means more than me being like, I can make a really good chart in Microsoft Word. It has to be a little more nuanced than that. So Kemper, if you'll flip to the next slide, you can see the list of primary duties here. It's systems analysis, it's design and implementation of computer systems, or a combination thereof. So essentially, if you're like me and you're looking at the slide and you're not really sure what that means, it's probably not meant to describe you, but it is an exemption just to be aware of. And if you'll click to the next slide, please. And then we have this outside sales exemption. This came up a lot during COVID when people were working remotely, and you may have spoken with us or other legal counsel about it during that time. The key for the outside sales employee is it's not tied to a salary requirement, but the primary duty has to be making sales or obtaining orders, and the employee has to be customarily and regularly engaged away from their regular place of business. And that includes, for example, if you have an employee who's working remotely, they have to be traveling away from that remote work location. It's not enough that you station them at their house and the house is 30 miles away from the company's building. So the sale has to be a sale, a consignment, a shipment, something involving a sale of a product, and the administrative support for another employee's sale is not enough. So if you have an employee making a sale and then you have like a customer relations person who kind of follows behind them, the customer relations employee would not qualify for that exemption. And then we have the highly compensated employee exemption. This is one that's specifically addressed in the new rule. And in some ways, it's what it sounds like, right? These are people who make enough money that the Department of Labor says, you know what, they really don't need our protection on the minimum wage and overtime front. But note that that person still has to be paid on a salary basis. so we'll touch on this in a second, but the salary component does still apply, and the employee has to customarily and regularly perform at least one of the duties you would see for the executive exemption, the administrative exemption, or the professional exemption. So it's not merely a pay threshold. And so here's this myth, right? If you make six figures, you're exempt from minimum wage and overtime. And there was a Supreme Court case here in the last year or so that addressed someone who was getting paid on a daily basis, I think to the tune of annual income somewhere around $200,000. But because they were being paid on a daily basis, they did not meet the requirements of the legislation. So again, it's just something to be aware of. These exemptions were drafted with the intention that they'd be hard to meet, because the policy behind having these exemptions as is to really only exempt those who don't need as much protection from the Department of Labor. So just again, a technicality to be aware of. I'm going to dive into the new rule for a second. Let's see, it looks like we have a question in the chat box. So there's a question about coordinating some volunteers with some other duties. It's hard for us to opine on specific facts without knowing more about the business and how the business operates. But in general, to the point that Kemper was making earlier, the thing the Department of Labor is really looking for is a lot of discretion in whatever those duties end up being. And so if the person is in a role where they're kind of carrying out directives from somebody else, I would be hesitant to jump to a conclusion that they're exempt. But for the person who put this particular question in the chat box, if you'd like to give one of us a call afterward, we'd be glad to talk through it with you. But again, discretion and autonomy is really going to be the key for most of these. So we have this new proposed rule that's been introduced from the Department of Labor. The Department of Labor captures it like it's restoring and extending overtime protections. So again, you can see the policy motivating this update. This is the third time in the last 10 years that there's been an attempt at updating these thresholds. One obviously was enjoined by the courts back in 2016, I think, and then there's been one update since then. The Department of Labor estimates that it will expand minimum wage and overtime to 3.6 million employees. So again, the intent here is to make it harder to exempt somebody. And if you'll go to the next slide, please. So we're in the middle of the comment period. And if you haven't dived into administrative rulemaking because you did not go to law school, that is understandable. There's a 60-day period where folks who have feedback they want to give on the proposed rule can submit that feedback. If you're interested in submitting that feedback, you can find it on the Department of Labor's website, or if you'd like to work with us to put something together, you can reach out. But the idea is that they're gathering comments from the public to analyze the practical impact of the rule that they've proposed. So that rule will end here, or the comment period will end here in November, and then we'll see some version of a final rule rolled out a while after that, depending on how long it takes them to synthesize everything into a final rule. And the Department of Labor recognizes there's going to be a cost, and this one in particular for our firm and the clients we serve is significant, right? They recognize that small entities, so small businesses, nonprofits, small local governments will be impacted, and there is, as you can see, a pretty significant cost associated with it. So the Department of Labor at least has made this determination that costs and benefits weigh in favor of extending these benefits to more employees. And so the big thing is there's a change to the salary basis here. So currently the salary threshold is $684 per week. They're looking at moving it up to what's currently a little over $1,000 per week. This is a fairly significant increase, but one interesting comparison point is this is tied to the 35th percentile of salaries in the lowest wage census region. So it is intentionally tied to, I think, what's intended to be an achievable standard. There are automatic updates to be made every 3 years going forward, so that perhaps the rulemaking process won't have to, we won't have to go through the whole process to update the salary in the future. And then the department specifically notes that that number is based on the census data that was pulled at the time they were putting the proposed rule together, but that they'll use real-time data when they roll out the final rule. So right now we're looking at a little over $55,000 per year as that annual salary, but it's probably going to be a different number by the time the rule is actually finalized. And then highly compensated employees, again, there is an increase here to 100, just short of 144,000. And the duties test for all of these white collar exemptions will remain the same.
All right. Moving on now that we have discussed really what the new rule is going to look like, we want to talk about just a little bit about some of the tips for complying with the new rule, and really being prepared for it. First things first, for the sake of being prepared, just assume the new rule is going to go into effect. It's just, again, for the sake of, we can't tell you exactly when it's going to go into place. We can't tell you what it's going to have in it. But just for the sake of being prepared, it's best to assume that it's going to go into effect. Next, you should consider how this salary threshold will impact your ability to hire new employees, right? If you are looking at hiring new employees before the rule goes into effect, does this increase in the minimum salary threshold change your interest in bringing on new employees right now? And this might very much be the case if that employee would have been exempt, but now might not be exempt anymore. But I think perhaps the most significant thing to start doing now is to start auditing your employee classifications. So what we mean by auditing employee classifications means, first, you want to go through and find all of your exempt employees, right? You want to determine, and again, this is the hypothetical you want to determine why you believe that employee is exempt from the FLSA. Are they covered by the administrative exemption? Is it the highly compensated employee exemption? Is it the executive exemption? So gather your exempt employees and determine why you believe that they're exempt. Next, you want to analyze what those employees' job duties are. And the reason you want to start with their job duties first is because you really kind of accomplish several goals in one. First of all, it's always great to just audit your classifications of employees. Is this employee actually meeting the job duties that the exemptions require out of the employee? But second, if you determine that the employee does not meet the job duties for that exemption, then you don't even have to move on to the second question of whether or not you have to consider the salary basis part of it that is now potentially being changed. So if you determine, after gathering your employees, determining what their potential exemption is, and reviewing their job duties, if you decide that they meet all of those job duties and up to that point are exempt, you now have to consider, well, will they be exempt if this new rule goes into place? And that's a pretty significant issue, right? I mean, if the employee is not going to be, if the employee is currently exempt, but with the increase in the minimum salary threshold, if the employee is not going to be exempt, you have a decision on your hands, right? And that decision is going to be, do I want to increase this employee's salary to make sure that they're exempt? Is it worth it to do that? Is it going to be too costly to keep them on as a non-exempt employee? If I keep them on as a non-exempt employee, am I going to have to make decisions on whether or not I allow them to work a certain amount of overtime? There's a lot of decisions that arise out of that kind of key question of, if they're not going to be exempt under the new salary threshold, how do you go about and handle that going forward? So kind of taking all this together, preparing for the new rule, as Jessi said, there are significant economic impacts out of this new rule, or there could be significant economic impacts out of this new rule. So just prepare for your business to have a change when it comes to, your pay scales, employees being moved over from exempt to non-exempt. It's going to have a serious economic impact on your business. So just be prepared for that if you have employees that are moving from exempt to a non-exempt status. But also really importantly, work with your counsel to properly communicate this to employees, because the last thing you want is to go through this process, determine that an employee has been exempt, is performing all the job duties required under a certain exemption. You decide that under the new rule they will not be exempt, and you decide you're not going to increase their salary, so they're going to become a non-exempt employee. And you sit down with the employee and you tell them, hey, you're no longer an exempt employee, and you have that conversation with them. The last thing you want is for that employee to start wondering, well, have I always been a non-exempt employee? Am I entitled to overtime hours that maybe I worked over the past few years? Am I entitled to minimum wage? Things like that. So it's important to make sure that this is communicated the right way to your employees. Additionally, I mean, of course, you want to review and update your workplace policies to the extent that they really get down to this level of detail. If you have handbooks, for example, or manuals that really get to this amount of detail about classifying employees, you want to make sure that those are updated. Remind your employees of timekeeping requirements. It's just kind of a good housekeeping item as well. And last, of course, train your managers and your payroll employees on requirements. These are the people that are going to be outside of your employees, of course, are going to be really, really having to deal with this the most. Your payroll employees are having to be cognizant of these changes, with exempt employees now being non-exempt and potentially being entitled to overtime. But also your managers, right? Your managers may now, if you have exempt employees who are now going to be non-exempt, your managers may start getting questions about whether or not certain employees can receive overtime or work overtime hours. So you want to make sure your managers are prepared for that, and know whether or not they want to grant those requests. And whether or not that's going to have an impact on their workforce as well. So with that, Jessi, I will turn it back over to you to go back through our takeaways.
So this is a welcome back if you have not been totally riveted by our presentation, and I don't know why you wouldn't have been. But again, if you take nothing else away from this presentation, know that salary requirements for the exemptions are increasing. Know that it's important to have a specific justification for why an employee or a position is treated as exempt from minimum wage and overtime. That there is a risk of misclassification that can lead to litigation, to investigations, to fines, all kinds of trouble. And now is as good a time as any with this new rule rolling out to audit and get your files in order. So if we can help you with any of that, we would love to do that. And you can reach out to either Kemper or me or anyone else on our labor and employment team through our website. And it looks like we have... Oh, sorry, go ahead.
I was going to say, I think we had one question in the chat box with any interest in increasing the federal minimum wage. As I understand it, there is a bill out there, but as I understand it, it's been reintroduced kind of year in and year out for quite a while. And so while there is a bill out there, it's maybe not quite the highest priority that Congress is concerned about right now. Would you agree with that?
Yeah, I think that's right. I don't see the momentum for it to get passed anytime soon. And for some additional background, the North Carolina Act is written so that it defaults to a specific dollar amount or federal minimum wage, whatever is higher. Right now, federal minimum wage is higher. So legislation at both levels right now seem pretty tied to that $7.25 amount. If there are other questions that you haven't had a chance to formulate, or if you have follow-up questions for either one of us, we'd be glad to answer them. But we appreciate you all spending your lunch hour with us. hope this has been informative and interesting, and look forward to chatting with you all soon.